All right, that's a perfect segue into our segment on rent control, which is going to be moderated by Joel Cohn, the Legislative Director for the Office of the Tenant Advocate. Joel.
Okay. Thank you, everyone, for being here, and welcome to this session entitled Rent Control, Where Does the District Go From Here? We are having this discussion in a truly unique policy environment. Over the past year, a wave of city and state legislatures have considered and in some cases enacted new rent control laws. Rent control has reemerged as a conversation that is more national, more international, more dynamic in terms of new ideas, and more consequential than it has been in 50 years. In June, the Chief Tenant Advocate and three of us on the stage now ventured to New York University Law School for a rent control symposium to explore these developments. Admittedly, that discussion got a little wonky and a little complicated. But what's clear is that the affordable housing crisis is affecting more and more moderate income residents as well as lower income residents who can no longer find affordable homes in their jurisdictions or are being priced out of their homes and who are not being served well by the unregulated market, to say the least, and not served at all by other government housing programs. As we heard this morning, within the last couple of weeks, two prominent members of Congress, Representative Alexandria Ocasio-Cortez and Senator Bernie Sanders, have proposed rent control programs that, if enacted, would apply nationwide. As for the District of Columbia, our rent control law will be up for renewal next year for the first time in 10 years. With so much reform in the ether, I think I lost my mic. Am I back? Good. With so much reform in the ether, it could be that not only will the Council renew rent control next year, but may also want to consider ways to improve and strengthen rent control. So joining this discussion about how to do it are Kelly Hunt, Policy Analyst for At-Large Councilmember Alyssa Silverman, Lauren Pear, who is the District's Rent Administrator, Beth Harrison, Supervising Attorney at DC Legal Aid Society, and Barry Weiss, who is the Legislative Director for At-Large Councilmember Nita Bonds, who chairs the Housing Committee. I want to provide a little roadmap for the flow of this discussion. Kelly's going to discuss recent reform efforts from around the country and takeaways from the NYU conference. Lauren, our rent administrator, will then lay out legislative purposes for DC's rent control law and offer her insights into how well it's working from her perspective administratively, not policy-wise. And then Beth will discuss how rent control is working, but how it may not be working so well and can be improved, and offer some reform ideas. And finally, Barry will discuss reform ideas and legislation that perhaps has been recently enacted and has improved rent control, and then further reforms under consideration for the coming year. In terms of format, we expect presentations to run about 30 minutes. Then we'll have 15 minutes for follow-up, and then hopefully about 30 minutes for your questions. As a reminder, if you have a question, there should be index cards on your table, so please write it down, raise your hand. OTA staffer will collect it and bring it back to the front. And please include your name and email address, because we're not going to get to all the questions most likely, and we do plan to respond to each and every question. So with that, I'm going to turn the program over to Lauren Pear, Rent Administrator.
Good afternoon, everybody. Is this on? Is this working? Can you hear me? Oh my God. Now? Now? Yes, now I can hear myself. So, Joel asked me to outline briefly the principles and legislative purposes of the Rental Housing Act. So my office, I run the Rental Accommodations Division at the DC Department of Housing and Community Development. And we administer the Rental Housing Act. And as an administrator, what we ensure that when we interpret the act and apply the act, that we take a neutral position. So, you know, we're not in favor of tenants necessarily, we're not in favor of landlords. We want to make sure that there's equitability that's built into any transaction. We also handle registrations that come in from the landlords. All rental housing is required to be registered and licensed in the District of Columbia. And then we also handle filings for rental increases, and also, for, elderly and disabled tenant applications to limit the amount of rent adjustments that those categories of tenants receive in the year. So we handle quite a bit of transactions for the district, for the tenant and landlord community. So what's unusual about the Rental Housing Act, at least from my perspective, is that it's one of the few statutes that I've come across that really lays out legislative purposes and findings. There are not many pieces of legislation or statutes that actually do that. And so when the Rental Housing Act was enacted, the Council of the District of Columbia Council made certain findings that undergird the Rental Housing Act. And really what it came down to is a severe shortage of rental housing stock and also affordability. And these are still issues that we're grappling with and discussing today. So it's an ever-evolving issue and discussion. But I just wanted to briefly also talk about, there are just 5 purposes that are addressed in the Rental Housing Act in the statute. And I'll read through them pretty fast, since there's just 5 of them. One is to protect low and moderate income tenants from the erosion of their income based on increased housing costs. Provide incentive for construction of new rental units and the rehabilitation of vacant rental units in the district. To continue the administrative machinery and resolution of disputes and controversies between housing providers and tenants, to protect the existing supply of rental housing from conversion to other uses, and to prevent the erosion of moderately priced rental housing while providing housing providers and developers with a reasonable rate of return on their investments. So I think we've succeeded in some areas, and we're still striving and working on others. So, you want me to keep going? What do you want me to do?
You're fine time-wise.
Okay.
You got more? Do you more?
Yeah. So one of the questions when we were preparing for this panel is Joel asked me what he thought, what works in the Rental Housing Act. And so when I was giving some thought to that, I was actually thought more in terms of sort of pinpointing exactly what works under the Rental Housing Act. I started thinking more about administratively what we do that works. And of course, there's always room for improvement, and that's one of the things that I struggle with, is always like, what can we do better? What can we do better? But I want to tell you, I'll start off on a positive note, what I think works really well. One is that we have a really seasoned staff of contact representatives. Many of you may have come in contact with them when you've come into our office or called on the phones. Most of my staff has been doing Rental Housing Act work for some of them 30 plus years. So I think we're very good about giving technical advice and guidance to our constituents, to our stakeholders that come into the office, and giving them good customer service about what they need to do to comply with the Rental Housing Act. I think we're also doing a pretty good job, and it's something I work on continuously, with interagency cooperation. The Rental Accommodations Division, or RAD as we're known, we interact with so many different other agencies to get the rental housing work of the district done. One is with the Office of Administrative Hearings, where tenant petitions are, where we refer the tenant petitions, and OAH hears the tenant petitions. We also have, of course, an excellent relationship with the Office of Tenant Advocate, who make our job so much easier by helping tenants that we can't specifically help if they come in with a legal question, because we can't dispense legal advice. So OTA has been a fantastic and supportive partner in our work. DCRA, of course, that they're the touchstone in terms of the starting process for landlords and getting their licensing, and also dealing with the housing inspections that are needed. And also with the courts, because they're, the Rental Housing Commission, of course, which has been Michael's chair, administrative law judge, I think that's what they're called now. Chief Judge Spencer has been a great support, and we support his office as well. And then we're also dealing with the courts. Another thing I think that works pretty well, and maybe because it's not so much of a process that we have our hands in, but is the tenant petition process, and moving, when tenants have a complaint against their landlord, how we process and move the petitions onto the Office of Administrative Hearings as efficiently as possible. And then we also work very hard, as I mentioned, at maintaining our neutrality and making sure that everyone, landlords and tenants alike, have a fair shake in the transactions that we handle. And the last issue that I'll give a plug on is that we also, I think, we do a good job on our outreach. It could always be better, and we're always looking for ways to make it better. but we have classes monthly, not only on Rental Housing Act issues, but also on the Rental Housing Conversion and Sale Act, which encompasses TOPA. My agency is very good, and inclusionary zoning, which is part of our rental housing administration at DHCD. We have monthly classes on a variety of topics. If you haven't signed up or you're unaware of our calendar, please go on our website, or you can give the Rental Accommodations Division a call, and we can get you a calendar. So one event that we're planning that's going to be coming up is, we call it a Saturday College, where we have classes all day long on a variety of rental housing topics. So, thanks.
Okay, so everybody hear me okay? Okay, great. So good afternoon. I'm going to kind of pick up where Joel left off a little bit in talking about the unique position we're all in right now. As someone who's worked at affordable housing for more years than I want to admit I've been alive, but I've also benefited from affordable housing in the past. It's really an important issue to me, and seeing it really emerge on the national stage is wonderful, and it helps give us some really good ideas for things that we can do here. I will correct something that someone said earlier today when they said that most of the presidential candidates have even presented their own affordable housing plans. I would say most of the Democratic presidential candidates have come up with their own affordable housing plans. But cities and states across the country are taking a new look at rent control. It kind of fell out of favor in a lot of jurisdictions. It's even prohibited in many. So what I'm going to talk about is what other cities and states are doing, and how we can look and learn from them and see if they have any brilliant ideas we haven't thought of, and what we might be able to do in the district. So the most comprehensive change has been recent, and it's been in New York State. In New York State, previously, individual jurisdictions could have their own rent control laws. What the New York legislature did, and the governor signed, was a new statewide framework, so that rent control was essentially legal and had some broad guidelines, on a statewide basis, and then local jurisdictions could then kind of tweak how they want at the local level. And some of the things that it did, I'm going to ask, do we have the PowerPoint? Because I was going to cheat and follow that. That's okay. It doesn't matter. That's cool. Some of the things that they did was, first of all, they deregulated what they referred to as the high rent exemption. So once a rent of a unit reached $2,774 a month, it was deemed to be high rent and could be excluded from rent control at that point. And as you can imagine, while that is a very high rent and something that I personally couldn't afford right now, there are a lot of places in, let's say, New York City, where it might be a very large unit with a family that could pay that, and they would then be looking at a great rent increase after that. Thank you. Now I can cheat. So that was the first thing that they did. Oh, okay. Now, see, I'm going to mess this up. Give it to me. One of the other things that they did was something that the council actually acted on earlier this year as well. Previously, a lot of cities had a 20% vacancy increase. So when somebody moved out, the housing provider could raise the rent in a rent control unit up to 20%. Council reduced, actually, the vacancy increase in the district to 10%. 10%. New York State wiped it out altogether, so vacancy increases aren't allowed at all anymore. In New York, they could, if a housing provider built some building improvements, they could tack on an additional 6% increase annually. They reduced that down to 2%. Let's see. A big issue that we've had in the district is a problem with rent concessions. So if I'm in a rent control unit and it's not at the maximum amount, the housing provider could offer me a rent concession and say, well, the rent should be $2,500 a month, but I can't get that because the rent is not that doesn't fit this particular market. And so they would lease it to me for $2,000 a month. And then when I renewed the next year, they would say, oh, nope, now it's up to $2,500, and I can't afford that. So it's something that the district is still grappling with, but the state of New York wiped that out altogether. They don't allow, you can still do a rent concession, you just can't charge up to the maximum rent when you do that. They also had a high income exemption for rent control, so if you made $200,000 a year or more for 2 consecutive years, you didn't qualify for rent control, they wiped that out. They did have an owner use exemption, so if I am a housing provider and I have a 10-unit building and it's all subject to rent control, I could say, oh, you know what, I actually need 5 of these 10 units for my personal use. That's probably not likely, so they limited that to 1 unit for 1 apartment for owner use. They did make it permanent. Instead of their rent control laws were renewable as well, but so they made this permanent. And then they also have the rent guidelines board still be the one who determines what the annual increases will be, which is a little different from everywhere else. One very large caveat on all of these sweeping changes in New York, they're being sued. The housing providers got together, filed a lawsuit. So this is not actually being implemented yet and won't be until there's some sort of resolution through the court process, whether it's some kind of settlement agreement or they, say they lose and they get to implement all of them. That's the most comprehensive change. But in other states, for instance, California in September passed a new statewide law. Again, there'll kind of be a theme. Cities could kind of do what they want, but they wanted kind of an overall framework to set. And so it's not a huge change, but they did limit the annual increases to 5% plus CPI, which is higher than what we have in the district. They also used this vehicle to create some new eviction prevention measures, which we're seeing a lot of in different states as well. Oregon in February did something similar, I think, and we'll kind of talk about this a little later as well, but I would really call this more of an anti-gouging regulation than a rent control regulation, so they limited their annual rent increases to 7% plus CPI. They exempted subsidized units from rent control, which is something that we do as well, and they set a little different measurement for which units qualify for rent control, and essentially new construction remains exempted, but once a building reaches 15 years old, then it becomes subject to rent control. Permits vacancy increases with absolutely no restrictions, and again, new eviction prevention guidelines. In Massachusetts, they've just had a bill introduced that is kind of interesting because in 1994, the Massachusetts voters voted to not accept a statewide framework for rent control, which essentially led to what amounts to a prohibition to rent control. So there's a new bill that would not create a statewide framework, but would allow local jurisdictions, cities and towns, which there's a distinction in Massachusetts, it turns out, between a city and a town. And so the cities and towns can decide what they want their rent control guidelines to be. With very, there's not a lot of regulation on what those cities and cities and towns can do. They can set for themselves what the maximum rent increase should be. It limits the properties that are subject to rent control to something, property that is 4 units or more. And it does require them to means test, but it doesn't set an income cap. So the cities and towns can decide for themselves what income level they want to make rent control applicable to. Florida also has a new bill that's been introduced that would, right now it's prohibited, but a city can petition the state to implement a rent control law. That's not largely accepted, so this new bill would actually give them a better path if a city wants to create rent control. And again, other cities and states are looking at different things, and kind of the 2 most common things that they are looking at is ways to expand the properties that are subject to rent control. But another idea that they're looking at is a way to encourage housing providers to opt in to rent control. So properties that are currently exempted, if you, let's say I've got a property that was built in 1995, and so it's market rate, no requirements, but if I would agree to set aside a portion of my units and make them subject to rent control, and probably have some sort of income or rent cap on it, then maybe I get a tax credit for that portion of my building, or maybe I get a property tax exemption for that part of my building. So just those are the kinds of things that are in the ether right now that we and a lot of other jurisdictions are looking at.
Thank you.
All right, so I feel like a lot of things I might want to talk about already have been said, but I just want to talk a little bit for a few minutes about some of the kind of the problems or the ways in which current law doesn't protect all the tenants in this room enough. And then, things we're looking at to try to strengthen the law as it's coming up for reauthorization. And I want to say something about how all of you guys can get involved. And actually, the next panel is going to have some tenant organizers who will speak more about that if you stick around. But we've talked a lot about how many units are covered. And so I actually worked with the 636 Girard Street Tenant Association. They were in a 4-unit building. And so depending on who bought that building, they weren't going to be covered by rent control. They had been, it was affordable, and the owner was actually going to sell to somebody who wouldn't have been covered by rent control. So trying to cover at least all those 4-unit buildings, changing the small landlord exemption, because the district has a lot of 4-unit buildings, and many of them actually are affordable at this point, but as gentrification continues, could be lost. And then changing the year. And so, as was just mentioned, Oregon actually changed it to be buildings built in the last 15 years are exempt, but then buildings would come under coverage. We could do that in DC. We could both move the year, but we could also make the law say, hey, every year new buildings come in, so it's just buildings built in the last 15 years that are exempt. And then voluntary agreements are a big problem, and many of you in this room may have experienced them or seen buildings that have experienced them. So they're really supposed to be something where landlords and tenants come together and agree on something that's fair to both sides. But it's one of those loopholes that's been exploited in certain ways, and Councilmember Che mentioned this, where current tenants sign something, but only future tenants have to pay the rent increase, which isn't really a good way to arrive at a fair agreement. And this is something, so I work for Legal Aid, and we've been working with the Coalition for Nonprofit Housing and Economic Development, CNHED, and some other volunteers to try to put together information about all the voluntary agreements that have been filed since 2006. And so I'm going to give you some numbers, and then I'm going to stop, because I know numbers can make all of us, our eyes roll back in our head. But during that time period, since 2006, there have been 240 voluntary agreements covering almost 6,000 units and resulting in total rent increases of almost $6 million per month on those units. And what we saw when looking at these is these agreements where the current tenants say, oh, well, I'll sign this, but I don't have to pay the rent increase. Those are the ones that result in really big rent increases. On average, they're about $1,500 a month, compared to other voluntary agreements are more like $500 a month in a rent increase. And even 500 is a lot, right? That's a lot. And so just looking at voluntary agreements, trying to make sure current tenants can't sign these agreements where only future tenants pay the rent increase, but also just thinking about ways to improve the process for those, the oversight of those. And then petitions are the things that landlords can file for really big rent increases. And so another building I'm working with right now is on Columbia Road, and they are facing anywhere from a 40 to a 60% rent increase under what's called a hardship petition. And that's because landlords are, under the law, have the right to a 12% annual return on whatever their investment is in the building. And that's a lot. So if you go put your money in, a savings account or anything else with your savings, you're not going to get 12%. You're not going to get anywhere close to that right now. So that's a lot that we're guaranteeing to landlords. And it results in these really big rent increases when those kinds of petitions are filed. And it's all at once. And so some ideas there would be to lower that 12% number, or maybe change the formula altogether, so it just looks at kind of, are they making a profit or not? And maybe they should be able to get, for example, a 5% profit, but if it's above that, they shouldn't be able to say they have a hardship. But also phasing in rent increases so they don't happen all at once, even if a landlord gets them. And then the last thing I'll mention on petitions, and this was mentioned when the council members were up on the stage, is a lot of buildings that are rent control have pretty serious issues. And this is not what we're talking about today, but I could speak for like hours and hours, and I'm sure all of you guys could, about DCRA and all the problems with DCRA. It's a huge issue, right? And so for petitions, you could require landlords to have to show they're complying with the housing code and improve that process. And another thing, and I feel like I'm stealing Joel's thunder, or Johanna Shreve, the chief tenant advocate, her thunder, because it's really an idea that I think they came up with, is that all landlords should have what's called a capital reserve. So basically they should have to set aside money for capital improvements over the years. And if that's not enough money, then they could ask for one of these larger rent increases. But they should have to show basically we're being responsible, we're running our business, best business practice, we set aside money for big things when they happen. And then if we don't have enough money, then maybe we're allowed to increase the rent on those units. And then I'm just going to very briefly, before I pass this to Barry for the moment, just mention there is a coalition of folks. It's called the Reclaim Rent Control Coalition that's coming together around reauthorization and trying to strengthen the law as part of that. And so there's going to be a press conference this coming week at a building, 220 Hamilton Street, at 6:30 p.m. But then there's also a rally, and I have flyers. So come find me, especially if you're disappearing before the next panel, because folks in that panel will have them too. But I have a flyer for that, and so that's going to be October 26th at 3 p.m. in Lamont Park. That's a Saturday up in Mount Pleasant. So I hope that you guys will consider getting involved in these efforts. You saw we had council members here, right? And they were saying some really good things, but that's only part of the council. And we need to get really broad support at the council if these changes that we're talking about are going to be part of reauthorization. And so I hope you guys will consider reaching out to one of us who's involved in this effort and think about ways you can get involved, come down to the council and so forth in the coming year. And how many months do we have, Barry? 3 months until the date for rent control to be reauthorized.
Hi, I'm Barry Wise. I'm the legislative director for the chair of the Housing Committee, Councilmember Anita Bonds. I'm going to talk about 3 things. Number 1 will be about some of the pluses and minuses and issues with rent control. Number 2, what the committee is doing to try to correct those problems. And number 3, I'm going to be asking for your help, because nothing, absolutely nothing on the council will happen unless council members hear from you folks, from your friends, from your cousins, your aunts and uncles, and anybody you know that is dependent upon rent control or affordable housing in any way, unless the council members hear from their constituents. When I go to Councilmember Bonds and my other colleagues who are in the room today, go to their bosses and ask them to opine on a bill, whether they might vote for it, the first thing any elected official, whether it's in Congress or the city council in some city in Illinois, they're going to say, what are the constituents saying? I see maybe about 300 people here today. Whatever the number is, there should be 3,000 people here today. And I'm serious. I'm not trying to put too heavy a burden on you. If a council member, any elected official, no matter what they want to do, no matter how right or wrong they think the issue is, if they don't hear from the constituents, the bill can fail. So that's my opening. Let me go back a little bit and talk about the issues of rent control. As you heard from Kelly, the district, I hope you absorbed this. When Kelly went over the other jurisdictions in the country, I hope you sense that the DC is way, way ahead of New York. New York is just catching up with us. They had a massive movement in favor of tenants recently, but it's a catch-up. And Massachusetts is behind us, and Florida and Seattle. DC is way, way ahead. We have a flawed rent control system, but it's the best rent control system we currently have. The problem with rent control is it's a very, very delicate entity. We live in a capitalist society, and that's great. I'm a capitalist, I confess now, a regulated capitalism. And if somebody is a housing provider, as long as they stay within the law, They are allowed to do, under our Constitution and our laws and under our capitalist society, to try to raise the rent as much as they possibly can, because guess what? Affordable housing does not, is Mary Chey here? No, good. Affordable housing is not in the Constitution, last time I looked. So you do not have a right to affordable housing in our Constitution. However, that is the policy of the District of Columbia. So what we have here, I like to make an analogy. It's kind of like a rent control is to affordable housing as a missile defense system is to our welfare as a country. Rent control began in its current form in the mid-1970s, and we've tried to improve it over the years. I've been working in the field the last about 4 or 5 years. And every time, as Mary Chey alluded to earlier, every time we write a rent control law, very, very capable attorneys, most of the time probably within the law, it's up to a judge whether they are or they're not, I'm not a judge, they come up with an idea to skirt around rent control, or they find or they dig a hole and create their own loopholes in rent control. So that's the anti-ballistic missile system on the other side, attacking rent control. Most of the time legally, and it's capitalism, and God bless them that they hired really good attorneys. But then it's our job, it's my job, and it's Kelly's job on the council, and our colleagues, Amir over there, and our nonprofit friends, and OTA's job to build another anti-ballistic missile system and fill all the loopholes in the law. And then they get that, and they come at it again. So this is our problem. We have capable people who want to make more money, and again, that's their right to do. But on the other hand, the city council has a policy of trying to protect affordable housing because we believe it's best for the city. It's social justice. Diversity is a good thing in of itself. Diversity also, in a slightly more cynical sense, is good for the economics too, because you have all this other talent who can take advantage of living in Washington, D.C. and all the advantage that brings. So what are we trying to do to fix this? In the last session, Councilmember Bonds and the committee and the council was able to move an extremely important bill that the work on that had begun 10 years ago under Jim Graham, and rental housing work had languished for about a decade till the current housing committee came into power. Sorry, I'll get closer then. Is that better? The current housing committee has worked very hard to stem the tide on rent control getting out of hand. We passed a bill that, as Kelly mentioned, lowered the vacancy increase from 30% down to 10%. If you do the math on that, if every time an apartment turns over, it increases by 30%, you have astronomical rents. Lowering it down to 10% will significantly help in that. Or 20%. Or, pardon me? Well, I can't give my personal opinion. You haven't elected me to the city council. But if we hear from you folks that you think 5% is a fair amount, then you know where my door is. That could help also. Everything is in steps because, again, before Jim Graham moved his reform bill in 2006, it was 100%. You could go up to the highest comparable unit in that building. Jim Graham did it, we live in an evolutionary democracy. Jim Graham got it down to 30%. The Housing Committee got it down to 10%. The next, 20%. Yeah, if they've been there a long time. Great, thank you. Anyway, we can move forward on that. The other bill, as has been mentioned here, is we're trying to reform all the petitions right now. In a hardship petition, I'm sure everyone in the room knows, they have a right to a 12% rate of return on their equity. That number needs to be tied to inflation. Back in World War I think it was at 6%. The number needs to be corrected. All the petitions need to be reformed. They haven't really been touched in decades. I've been working with a task force trying to reform all of them. I believe we'll introduce all of those bills on hardship petitions, substantial rehab, facilities and services, capital improvement, and reform all those bills because they can be really harmful to rent control. Another thing that's been mentioned is the voluntary agreements. We're working on reforming them. We've been meeting with all sorts of folks, all the stakeholders on this bill to try to come to an agreement, and we're about at the point where I'm going to recommend to the committee that it's time to take the pot and do something with it and make a decision on that, because vacancy agreements, as Beth pointed out, have been really, really harmful to rent control. I'll mention one other bill that was very important and give a shout out to Harry out there. We redefined what rent charged meant, because as has been mentioned before, people would increase your rent not on the rent you were being charged, but on the rent on the number that they had sent down to the rental accommodations division, which could have been a much, much higher number. Our bill paralleled what the Rental Housing Commission had decided, and the reason why sometimes you have to pass a law even though a judicial body has made a decision is that judicial body can change its mind. They're not likely to, but another 1 year or 2 years they can change your mind. So now we have a law that says when you increase your rent at the end of that year and you're allowed to increase it 3.4%, you increase 3.4% on what you're actually paying, not some number that only exists on a piece of paper filed away with the city. The last thing I'm going to say again is to emphasize we cannot do anything unless you folks dedicate yourself to knocking on doors. It's not going to happen. This room can fit an awful lot more people. The first time I ever stepped in City Hall, I was in law school at the time. I didn't even know where City Hall was. I had to look it up on the map. There was a big controversy over this TOPA thing where a housing provider would pay 95% of the cost of the building, and then they wouldn't really own the building because it was only 95%, and then they would convey the last 5% to them at no additional cost. They said, well, we don't have to do TOPA. We don't have to give the building to tenants. And they had a hearing on this, and the hearing lasted for 3 days. Since then, I have never seen a hearing on a tenant issue, whether it be TOPA or rent control, that lasted for 3 days. I didn't know anything about anything. I'd never been in City Hall before, and the council member who was chair of the committee cut me off because I started talking about how my building got cheated out of its TOPA. She said, we don't want to hear about your building. Well, I just kept on talking, and because I didn't know the protocol back then. I don't know if I would have had the courage now. But the point is, you have to come to these hearings. We're having rent control reauthorization. If we do not pass this bill, I know every single council member is going to raise their hand, but there are folks, I'm hearing rumors, there are folks who are saying, we're going to fight this because rent control is actually bad, and rent control causes rents to rise, and they have their old Reaganomics trickle-down theories. Well, we cannot win that fight, because if we don't win that on December 31st, 2020, if you're in a rent control building and we don't get it reauthorized, assuming you're not under release or you're not under your month-to-month, that rent control, your rent, if your rent, shoot, hello, oh, we lost it. Can you hear me now? I'll stand up because I'm wrapping up anyway. Can you hear me now? Yeah. Okay. If we don't pass the reauthorization, if we don't have at least 3, 5, or 2 weeks of hearings, I'm serious. Councilmember Bonds, she's got the physique to sit there and listen to everybody. She will listen to you until every last person has spoken at the hearing. December 31st, 2020, if your rent now is $11.50 and you're living in a legacy, naturally affordable apartment, wherever, it could go up to $2,500 the next day as soon as your lease or your month-to-month is up. That is what is at stake. I cannot emphasize this more. When we have that hearing, I want to see hundreds and hundreds of people there. And before the hearing, I want you knocking on all 13, well, 12, because my boss is committed, all 12 other council members' offices in a long line saying, I can't pay my rent if it goes up to $2,500. I can't feed my kids. I can't pay my medical bills, I can't put shoes on my children, and I can't buy school supplies. And if they don't hear it, I mean, you want to blame me for not getting the bill passed? That's fine. But I'm going to point to you folks, we need your help. Thank you.
Is this mic on? How about now?
This one?
Anyone has one battery? Is this mic on?
It says on, but it's not on.
No, the light's on, the system's not on.
Hi, everybody. Wow. It's out. Okay, I will talk loud. I hear the mics are out. Hopefully that will be corrected quickly. Can people hear me in the back? Can people hear me in the back? Okay, I'm going to do my best, and apologies. There are empty seats if people want to come from the back and come forward so you can hear. That would be very welcome. What I want to do initially, before we get into questions that we don't have housing providers on the panel, obviously, because this is about how to make rent control work better, not whether to have rent control. But there are legitimate balancing questions that need to be asked, so I do want to ask a couple of those questions. And then also, as I indicated, Kelly and Lauren and myself accompanied the Chief Tenant Advocate to New York University for this third generation rent control conference, and we want to talk about some of those new ideas. But before we go there, I'd like to get a sense from the panelists about recent enactments, recent rent control reforms that they think have been the most impactful. And there actually has been quite a lot of activity, not necessarily on a major scale, but fixing smaller problems with rent control over the last couple, 3 years. And so I have in mind, for instance, I'll ask Barry to discuss the Elderly and Disability Protection Act, which just got further funding last year through the rental unit fee increase. And Beth, I'll ask you about the subsidy exemption upon expiration, establishing a base rent, to explain that. And Kelly, this is not rent control, but it is a senior subsidy that got put into the budget last year. So if you can talk about those things, and hopefully we'll have sound by the time you're done.
There's something. There. Try. There. No one. Working.
I think it's working.
Woohoo!
Yep. Thank you. One of the that didn't last. Oh, are we on? No. Okay. One of the first bills that Councilmember Bonds put before the council was a bill that did a holistic review of everything rent control did in relation to senior citizens and persons with a disability. And one of the main things the bill did was to protect them against a petition increase that would wipe them out. And what it would do would offer it funded a tax credit to a housing provider who had a senior or a person with a disability, so that person would not have to pay the increase due to the capital improvement or the or a hardship petition or whatever. And it also protected the housing providers because we can't just take, and so the city provided a tax credit. The other thing it did was to add the Social Security increase as a least common denominator option for the annual rent increase. So what that meant is if you have a limited income and you have Social Security and CPI went up plus 2 went up, well, it was be CPI alone for a senior citizen. If CPI went up more than your Social Security check did, then you were eating less or not taking your medicines or whatever, unfortunate. So whatever is the lowest, the CPI or 5% maximum, which hopefully we don't go there again, or the Social Security increase would be how much your rent could be increased. And then finally, the bill just did a whole bunch, a little bit of cleanup. We heard a lot from AARP and their representative to the kinds of things that would help seniors and persons with a disability stay in their homes and wouldn't be crushed by rent control. And I had a lot of help on that bill from the folks you see on the panel and all their colleagues.
On that topic, just real quick, and I think you guys are here because you probably understand your rights under the law. If you are in a rent control building and you are elderly, 62 or older, or have a disability, or your neighbors do, please make sure that you fill out your forms, file them with the government to have that recognized so you can get lower rent increases. And if your building gets one of these petitions, you will be protected. So the building I was mentioning I'm working with right now, about a third of the tenants are going to be protected because of this new law. And those tenants, I'm worried about the others, to be honest with you, but those tenants will be able to remain in their units if they so choose. And so that's a really important, impactful law. Joel mentioned this subsidy bill, and so a question was asked when the council members were up here about subsidized units being exempt. So a tenant with a voucher moves into a rent control unit, and then it's not covered by rent control. And there are a lot of reasons for that, because there's a different, set of rules. Usually it's federal rules, and those have to, we say, take precedence, preempt, basically those rules we have to follow, and you can't have a local rule that's different if there's a federal rule in place. But the problem we saw is many of you may know that tenants with vouchers, the housing authority will actually pay sometimes higher than what the rent control rent is, right? And, if you're a tenant with a voucher, that's a good thing. It maybe allows you to move into a better neighborhood. And so it's good in that sense. But what it means is that then when that tenant left, if the owner wanted to put that unit back into rent control, under the law, it reset the new rent at that higher number. So it didn't go back to the rent control rent from before. It just stayed at that higher subsidy level. And so we didn't think that made a lot of sense. And so the council enacted a law through the housing committee that said, okay, if you have a tenant with a voucher who comes in, when they're there, you can pay that higher amount, get that higher amount in rent. When that tenant leaves, if it goes back under rent control, it's going to be what the rent control level was before, plus the CPI increases that happened in the years that went by. And we thought that was a good way to make sure that we don't have landlords renting to tenants with vouchers for the wrong reasons or using those tenants to try to get a big rent increase and then kind of booting them out. So that is just going into effect, and we hope that's going to be helpful on that issue.
Since that one works, why don't we just
pass it.
Since we know it works. So as you all heard my boss, Councilmember Silverman, say earlier, we have to use every tool in our toolbox, right? And one big tool that we have and that the district invest quite a bit in is our voucher program. So we get federal vouchers, but the district also created its own voucher program that mirrors the federal program. Still, we have 40,000 people on that waiting list, right? And I think somebody said it essentially is a 27-year wait. That's not going to help most of us, right? So what Councilmember Silverman did, and Councilmember Bonds very kindly moved forward and funded, was what we call a shallow subsidy for seniors. So, frankly, it came from talking to my next door neighbor, who is a 75-year-old woman on a very limited income. And we were just, frankly, sitting having a glass of wine one night, and she said, if I just had an extra $500 a month, I could make it. And so we created the shallow subsidy that actually Councilmember Bonds increased to $600 a month for seniors, and it was funded in the FY19 budget. The Housing Authority administers it, and as happens when you create a new program, it's taken them a while to get it off the ground, but they are now, you had to already be on the Housing Authority wait list because there is not infinite funding for it. So it's essentially kind of a pilot right now, but they have kicked it off. They are actually processing people right now, and we hope to be having people actually accessing the funding in the next couple of months.
Is this one? This one's not working.
No.
Thank you.
If you're on the Housing Authority waiting list.
On the Housing Authority waiting list, which is closed right now. So, if you're not on it, unfortunately, you can't get on it. But if you're already on it.
Okay. So, Lauren, sorry for forgetting. Lauren indicated she didn't get a chance to get into what's not working so well with rent control. Again, from an administrative perspective, not a policy perspective. So if you can do that, and then also, speaking of administration, I think everybody here is probably aware that the Rental Housing Commission is the administrative appellate level of review of rent control cases. So you have a rent control challenge, you file a tenant petition, it's heard before the Office of Administrative Hearings, and then you can appeal that before it goes up to the DC Court of Appeals at the Rental Housing Commission. And the Rental Housing Commission was made officially, I guess by way of clarification, independent in a law that became effective just earlier this year, I believe, or late last year. So if you can do your critique, administrative critique, and then each of you can comment as you wish on the commission legislation.
Yes. Sorry, I forgot the balance part of everything that we do so well, and I omitted the stuff that I feel that could be better about the Rental Housing Act and about what we do administratively. So just to be fair about it. One is well, before I get started on that real quick, I do want to say, and I think it was echoing either what Beth or Kelly said, one of the things, I tend to live in a silo sometimes, and I don't look up from my pile of work, but going to that NYU conference was so eye-opening to me. I've lived in DC since 1977. I'm not native, but I am a long-term. I graduated from Wilson, go Tigers. But one of the things I've taken for granted about living in a city is how progressive we are, and how many good pieces of legislation that protect people come out of the council and also are put forward by Mayor Bowser. And so being present at this conference with folks from all over the country talking about rent control and really grappling with it, and we were modeled on New York. Our rent control system was modeled on New York. We've surpassed it in so many ways in terms of our tenant protections. And I, for one, I take it for granted. And so I was really humbled by that experience and learning that aspect about how I just need to pick my head up and look around a little bit more. Can it be improved? Yes, things can always be improved. Our culture changes, our history changes all the time, but I just wanted to make that one personal note of how humbled I was to and be really grateful about where I live and how much we care about one another. So what I think could be improved about the Rental Housing Act from an administrative perspective, one is that data. We lack data. We are so heavily paper-based. My God, can I just tell you the volumes and volumes of paper that come in? And there's always inevitably one person who says, I want a copy of every rental registration form that you have. Well, it's impossible with the amount of what we have. Now, you can come down and inspect by law under the Rental Housing Act. You can come down and look at our records, but you have to have the property address. So if you're trying to take a survey or find out, or even find out the number of how many rent control units we have, I can't tell you that. And it's so frustrating. So one of the things that Councilmember Bonds created a mandate to create a rent control database system. And that effort is being put forward being run by the Office of Tenant Advocate, and I work very closely. Amir Sadeghi, I don't know if he's still here, he's the point guy. He's done an awesome job. And just so you know, we deal with bureaucracy too. And so Amir has been great about pushing the project forward. So I'm really excited about it, and I'm hoping by June of 2020 that we'll be standing in front of you with a great database, and we can actually start getting data on how effective rent control has been for the district in the last 40 years. So this is not an uncommon problem. It's common across the country. There just isn't enough data about rent control. So something to look forward to, something to encourage your landlord when they have to re-register. So stay tuned for that, as my director likes to say. Another issue that I'd like to see, and I'm not slamming anybody on this, so please don't take it as a criticism, but I'd like to it would be helpful if petitions were processed faster. It creates a real economic hardship for tenants and landlords alike when we can't get the petitions out. I went to a DC bar function recently where some administrative law judges from OAH were speaking, and as I recall, and Beth, correct me if I say this incorrectly, I recall one of the judges saying that they process 20,000 petitions a year. And that to me is just mind-boggling. So it would be great if we can figure out in our discussions what we can do to ease that administrative process so it's not impacting the parties so severely. We have to have the due process. It's a complex property right, but we have to be creative and think of ways to help OAH with that process. Another issue that's been brought up many times is voluntary agreements. Voluntary agreements in their present form is just not working in our view. It's just another tool by which properties are rapidly moving out of rent control. And so as a policy, as a city, if you as tenants, as stakeholders, if Beth, if the other tenant advocates perceive that this is not where we want to be, we really need to urge you to work on coming up, working with Barry to come up with something that does work. I mean, we want to encourage voluntary cooperation between landlords and tenants, but not at the cost of future generations of rent control. Another issue that we have administratively, we have a little trouble with is that, there's only, under district law, you can only evict for certain reasons. Breach of lease is one of them, and one of the things we see in landlords really grappling with are 30-day notices to vacate for tenant conduct. So recently, for example, we had a notice to vacate that came in because the tenant was taking too many pictures of the property manager. Like, what do we do with that? How do I enforce that? What do I do with that? Now, I get that the property manager might have felt a little threatened. These two parties did not have the best relationship, but when this is put in my lap administratively, what do I do with that? I just call the attorney and yell at them and say, well, what? So I'd like to see maybe, and of course the tenant was upset, and so, it took a lot of mediation between the parties to kind of talk everybody down. And the last issue that I think that we could do better under the Rental Housing Act is that there's really no registration adjudicatory mechanism. And what I mean by those fancy words is that if I have a landlord who shows up at my front desk with a registration and there's some corrected representations, okay, they forgot to sign it, they forgot to fill out the form, my folks can correct that, have them correct that on the spot. But if it's a substantive kind of correction, by law, I can't reject that registration. What happens is I have to do the intake, take the form, the incorrect form, and then do compliance afterwards. So there should be a mechanism so I could reject something that I find substantively wrong, but gives the landlords an appeal or a due process to challenge that determination. So I know that's a little technical, but that's something that we kind of grapple with on a daily basis. And I think the second part of my question was about the Rental Housing Commission Independence Act. So just to give you a little bit of history, the Housing and Regulation Administration, which is comprised of the Rental Accommodations Division and the Rental Conversion and Sale Division, known as CSAD, were originally housed at DCRA back in 2006. Or so. Then there was legislation that literally picked us up and moved us to DHCD. I believe the perception at the time is we weren't being resourced properly, and this was a way to get us the attention we needed so tenants were not, DCRA wasn't making decision. Do I deal with the elevators that are, malfunctioning, or do I deal with this poor tenant who's got, all kinds of problems with their landlord? So I think that even though sometimes I feel like we're a strange fit at DHCD because they're in the business of building housing, not regulating housing, but they've done a pretty good job about making sure we stay resourced and helping us with our mission. The Rental Housing Commission came over with us in that transfer of authority, and so they retain their independence to hear cases that came up to them on appeal from OAH and from the rent administrator's office, but administratively they remained under DHCD. And what I mean by that is that DHCD had oversight over their budget, their personnel, and so they didn't have complete independence. So last year, I think it was, the council made the Rental Housing Commission independent. From my limited perch, I think that there were really genuine and significant efforts made on DHCD's side not to interfere with the Rental Housing Commission and their business. But again, their budget was married to the agency. So now they're completely independent. The commissioners, the name has changed. I believe they're administrative law judges now, so they have the official ALJ title. And as Michael Spencer, the chair, mentioned earlier, Tuesday's their big day, their big debut. So, I wish them well, and we'll continue to work with them and have a great relationship with the Rental Housing Commission. I'm sorry, anybody want to comment?
Any other?
No?
Okay. Is the mic still working? Okay, great. Yay. So my landlord question is that, as Laura laid out very well, the legislative purposes of the act require a balancing between affordability for the tenant and some measure of profitability for the landlord. A different issue is the 12% guaranteed return on the investment too much, too high, and puts too much of a burden on tenants. But the question that the landlords are quick to point out with some legitimacy is that you have rent control buildings, by definition, is an aging stock of buildings. By definition, also, truer more in some cases than others, rent control means lower rental revenues. So you have less money to pay for more extensive repair needs. And the landlords are oftentimes, when it comes to the voluntary agreement, making common cause with tenant attorneys who are put in the position of being responsible and professionally responsible for zealously advocating for their clients who are poor tenants who can't afford the rent increase. And then these VAs start happening. The cost shifting in terms of approving rent increases that the current tenants are not going to pay, but that's bad for the affordability of the stock, obviously, but it gets repair dollars in, is the theory, for correcting the building. Now, another question occurs to me, which I'll get to, which is that really the scenario, or what happens? I'm going to turn to Beth for part B of that question. Some newspaper articles point out that that's not quite the case all the time. But the point is, a big part of the discussion in New York involved what creative new ways can there be to make sure that owners of older buildings, rent control buildings, do have the finances that they need to fulfill their responsibilities. Beth, I appreciate mentioning the capital reserve account idea, and maybe you might want to flesh that out a little bit more. There's also the idea of tax credits that came from the New York conference in two different contexts. One of which was more money to pay to tax credits would provide for more money in the pocket of the owners to be able to afford to pay for the repairs, in the absence of more rental revenue. And there's some other ideas out there as well, but that's my landlord question. And anybody want to tackle that?
My initial reaction is that we actually have most of the tools we need right now. They just don't function the way that they should, specifically hardship petitions. And kind of going to Barry's point on our petitions need a really close look and frankly an overhaul, and not just at the on the 12% matter. And again, not being overly critical of any particular group or person, but these petitions are affecting people in real time, both on the tenant and the housing provider side. They need to move quicker, right? And so across the board. So I actually think we have most of the tools we need already. We just need to be better with them, and they need to be more productive for both the tenants and the landlords.
Full enforcement.
So, I think sometimes it's important to acknowledge that two conflicting truths can both be true at the same time. So I certainly think there are some rent control buildings where, the rents right now, the owner doesn't have enough money to pay for repairs to make capital improvements. To be honest with you, I think there are a lot of buildings as well where the owners have that money and that's not where they're putting their money, right? It's going to the investors. Sometimes the investors don't even live in DC. Sometimes they don't even live in the United States. They may be folks from other countries, and basically that money is going out of the district and even out of our nation. And so I think the trick is we have to figure out how to help the landlords who really do need help, but not have too many loopholes for the landlords who don't. And so the capital reserve account is one idea, is requiring landlords to set aside money for this purpose. DHCD has a small building program for repairs. I think the ideas like that, as Kelly's saying, we have a lot of ideas out there that could be expanded. And I think, tax credits or policy like that to get money for repairs. And I'm not remembering if it was Councilmember Silverman or Nadeau or both who were kind of talking about the need for repairs, but also trying to not put all of that on the backs of tenants and trying to figure out more creative ways where landlords need money to get it to them, but hopefully not making, tenants have to pay huge amounts for that. And part of the problem we see with voluntary agreements is exactly that if you're a current tenant and your rent's not going up and it's the future tenants who have to pay, you may not get the improvements in your unit. Things may be structured that way. Also, sometimes there are promises made that are not followed through on, and then you have to go try to find somebody like me to, go into court and help, and there aren't enough people like me to help low-income tenants who can't pay for lawyers. And so I think there are ways that we should tighten current rent control law, but also think of other mechanisms to get money to landlords to make repairs when that's the issue. And then finally, enforcement with DCRA. Again, we could have like an all-day conference just on that topic, but that process is broken, and so anything we can do. And I'm just going to echo what Barry and I have both said about DCRA. There are potentially going to be some bills moving this year, or some ideas that are out there. Councilmember Nadeau mentioned her bill about DCRA. And again, we need folks to come down when there are hearings on those bills to reach out to your council member and say, hey, this is the experience I had. It's not working for me. There aren't enough inspectors, so provide more inspectors. The inspectors aren't doing a good job in this way. They need to improve. But the council really needs to hear not just from folks like me who work with tenants, but from everyone in this room who's experienced those kinds of problems.
Great. Okay, I'm going to move on to your questions. We're going to need to wrap up within about 10 minutes. So answers concise, please. So Lauren, I think this question is for you. How does a new tenant find out what the rent was before he or she moved in, so the increase they are paying is correct?
So that's actually a pretty easy question. You can contact the Rental Accommodations Division. You can come in person. We're at the corner of Good Hope Road and Martin Luther King Jr. Avenue Southeast. Our address is 1800 Martin Luther King Jr. Avenue, to the Housing Resource Center. And if you choose to come in person, you can, we have workstations where you can review the rental history on a particular project. So building, You'll need to have the property address and the unit number. Another way you could do that is you could also just call my office to get instructions. And, if it's not too complicated, we may be able to do the research for you. The Rental Accommodations Division number is 202-442-9505. Again, that's 442 9505. The Housing Resource Center is open Monday through Friday from 8:30 a.m. to 3:30 p.m. Please do not come in at 3:25 and ask for and want to sit at the workstation and do a comprehensive search. Give yourself enough time and give us enough time so we can help you, particularly with the database program that we have. So a new tenant can come down, call us, and we'll help you conduct a rental history research so we can help you calculate and do a rent analysis. Sorry, I talked too long.
Okay. Thank you, Lauren. Next question, why does the low-income housing in Georgetown have such high security deposits? So I can begin by saying DC law restricts the amount of a security deposit to the amount of 1 month's rent. So my guess about what's going on there is that the unit is subsidized and the security deposit equals the full amount of rent, not only that the tenant pays, but that gets paid to the landlord by the government.
So that is right. So tenants who have a subsidy still have to pay the full rent as a security deposit, which is really hard if you are an individual who has very low income. So I will mention two things that folks should be aware of. One is the Emergency Rental Assistance Program does not have enough money and needs more money, but does provide some limited assistance on that. The DC Housing Authority for the local, so we talked about how there are local vouchers and there are federal vouchers. If you have a local voucher, the DC Housing Authority now has a program to pay for security deposits for tenants in that program. And again, that's something that, perhaps we could think about expanding. And so if you're facing that problem or your neighbor or friend is, you should look into whether either of those programs might be able to help.
Thank you, Beth. Next question might be for Kelly. Kelly will let us know if it's for Kelly. What efforts have been made to research rent control programs in other cities, Los Angeles and New York City, and whether aspects of these programs could work in this area? And I'll just begin by saying our office, I believe the committee, the advocates, Beth very, very prominently, does a lot of research into best practices in other jurisdictions. This kind of dovetails into my question, I guess for Kelly, about takeaways and maybe what your thoughts might be about those ideas that were generated out of the NYU conference, and in particular, we might talk about ways to expand rent control. You had mentioned anti-gouging. We mentioned, I think, the tax credit for voluntary participation in rent control. And then, of course, you covered the eliminating the new construction exemption after 15 years, which Oregon is the jurisdiction that adopted.
Well, I'll start by saying, and it may not look like this as much as it is, but actually researching what other jurisdictions are doing and what best practices are and just brainstorming is a big part of what everybody up here does all day long, because this is actually, affordable housing is actually a passion for all of us, and we're always looking at ways, especially living in a city like DC, where it's such a hardship on so many people. So that is actually how we spend a lot of our time. And it's also where we have, I think someone took issue with the idea of stakeholder meetings. That's what all of you are. It's what we are. We sit and we talk about these things and say who has like this brilliant idea. And it's why so many of us went to the event at the Furman Center. It was an opportunity for us to research and see what other jurisdictions were doing. And one of the big takeaways that I came away with is because my council member does think that more properties should be subject to rent control. And so we were thinking about, we saw the idea of a tax credit or a property tax exemption to incentivize a housing provider to opt in voluntarily to participate in rent control. But why, I guess the end point that I'm going to make is that why, echoing what Barry said about having you guys all at the table and telling us about your opinions, and just sitting off to the side, and she's not here anymore, I'd love to give her a shout out, but when we were talking about expanding when the council members were up here and we're talking about expanding the age of the units that would be subject to rent control, Director Donaldson pointed out the fact, well, that's actually going to impact the inclusionary zoning program. Because that's the program that impacts new units. So we're going to have to sit and figure out a way, if the council does decide to expand the properties that will be subject to rent control, or we do offer an opt-in, how is that going to interact with inclusionary zoning? Because inclusionary zoning has created thousands of units of affordable housing already, and it's a great program that DHCD monitors and administers, and we don't want to hurt that program, but we do want to expand this over here. So again, talking about all the voices that need to be at the table, echoing what Barry said, make sure that you're knocking on our door, calling us, letting us know what you think, and come to the hearings and tell us what you think.
Thank you, Kelly. Let's see, we have a closing comment. Well, okay. If you can keep this answer to 2 words or less, yes or no, and then one. Does it make sense to reorganize rent control by tenant's income, not necessarily by unit status, i.e., I take that to mean means testing? And I'm going to let one panelist answer that. Beth, do you want to be the one?
My answer to means testing is no. Part of that, I will just say, is when I've seen proposals from the landlords about this, it would result in far fewer units being covered. They would decontrol units. And so we need to keep as many rent control units as possible. So that's my answer.
Good answer. Thank you, Beth. So there is one more question, and it dovetails. Is this mic working? I can't tell. It is. So I want to dovetail this question about when, where, and how to testify, which is a great question. I'm going to throw it to Barry after making my brief closing to just reinforce your role in the history of rent control. Sean, my colleague, gave an excellent presentation this morning. I do wish there was one more photograph that had been included in that presentation, which would be a photograph of my 2 bosses in DC government, Councilmember Jim Graham and Chief Tenant Advocate Shreve, together with a room full of OTA stakeholders. And I think it's possible such a photograph exists, but I'm not sure. But Councilmember Graham just absolutely cherished being a soldier in an activist army, working with stakeholders and with tenant activists and tenant attorneys. He called it trench warfare, and it what led to the most productive and successful period of rent control reform and TOPA reform and others in the history of the DC Council. He lost his chairmanship after 2 years because he was so successful and because he was so good at mobilizing tenants and tenant activists. When he passed that torch, when he gave up the chairmanship involuntarily and passed that torch, he passed it to Chief Tenant Advocate Johanna Shreve, director of the agency he created, as Sean pointed out. And he continually and very very nicely, I'll say, took a lot of time to reinforce and to reassure the OT that we're doing a good job, that Chief Tenant Advocate was doing an excellent job in terms of keeping that coalition together. There's many more and furthering rent control reforms. We were able to work with a lot of folks in the community and with stakeholders to develop reform proposals that he could then introduce. Some of which took a while to get done even after he left the council, and others of which are still yet to be done. But he really understood the importance of the leaders, whether it's a chief tenant advocate or an elected official, to have that army of activists behind them so that democracy works and that the voices of the people get heard, and that's how change can happen. So I really encourage you to stay tuned, keep working with OTA, keep working with the new tenant union, the new tenant organizations, which are doing great. We're all talking and collaborating a lot on these reform proposals. I guess I'll leave it at that. When you guys are involved, good things can happen. And so I really encourage you to stay involved. And I will say, if you're not getting information from OTA in terms of what's happening at the council, what is the council up to, when are the hearings, sign up on the, I think there's going to be a pad outside of the conference room. I'm looking for Steve, and I think we are going to be taking additions to the listserv. So please do that. And when a hearing happens, go testify. Thank you. Oh, help me thank the panel, please. Thank you. Oh. Last question. Barry, when, where, and how do you testify? Is that the question you want? Yes. Okay.
That is, oh, hello, are we on? Thank you. 724-8064. I don't have to tell you that's 202 because that's City Hall, and it's located right in the District of Columbia. 724-8064 is the number to call to testify on any hearing by the Housing Committee. Now, to share this, we have lots of other committees that you can testify on in the City Council. We have hearings on health, and we have hearings on the judiciary and the workforce and all sorts of stuff. As a resident of the District of Columbia, it is your right to come and testify at a hearing. I'm going to close this with some substance of how what we say your voice has to be heard, how it actually can be heard in the history of rent control. I don't know if it was touched this morning, but the original law had vacancy decontrol. Once an apartment got too high, then it fell out of rent control. That was the wisdom of that city council 40 some odd years ago, 45 years ago. But the citizens of the District of Columbia rose up and said, no way. You're not going to take units out of rent control once they reach a certain amount. And there was a referendum by the residents of the District of Columbia which overturned the action of a city council with a slightly deaf ear at the time. So let's save the money on the referendum and not have to have and let the city council hear before they make the wrong vote and go the wrong direction and get the bill right the first time. And that way, those of us who write laws here don't have to write it twice. What a waste of time. So the referendum is a prime example how citizens rose up, overturned the city council's issue on one of the issues and changed the law. So that's what we're challenging you to do. You leave here today, it was nice hanging out with you, but let's make sure something comes out of it.
Okay. Thank you very much to the panelists and to everybody for being here. My job is now to turn this back to Mr. McGinty.